In 1975, when IDEA was enacted, about 3 million children with disabilities were receiving inappropriate education, and about 1 million were totally excluded. About half of students were being provided an appropriate education, and this is because identification and placement was haphazard, inconsistent, and generally inappropriate. Parental involvement was discouraged. We wanted to avoid disruption, and general and special educators were competing for resources. 2 decisions, one in the District of Columbia and one in Pennsylvania, were the impetus for enacting IDEA, the Park and Mills decisions. These courts determined that the current method of exclusion or inappropriate education was a violation of the Equal Protection and Due Process clauses of the Constitution. These decisions were important because they signaled that other states were probably in violation of the Constitution. The potential for varying decisions and the high cost of providing special education resulted in congressional intervention. There are a few basic principles of IDEA. Education must be provided for all students with disabilities in the least restrictive, appropriate placement. It must be individualized and appropriate. It must be free to parents, and procedural protections must be in place. So how does this relate to our state special education laws? Federal funding is provided to states to provide special education within a framework of each state's law that complies with the federal IDEA framework. There have been several amendments to IDEA since 1975. In 1990, we replaced the word handicap with the word disability. In 1997, provisions were added related to high expectations and outcomes, as well as access to the general curriculum. And in 2004, amendments clarified the connection between No Child Left Behind and IDEA. There was a focus on prevention and technology, early intervention, and evidence-based practices. Other changes related to the IEP requirements like team meetings, reevals, parent rights, discipline, dispute resolution, attorneys' fees, and paperwork. IDEA is often criticized as an unfunded mandate. Something that you want to think about is this: if states are not required to accept federal funding for special education, why do they do so if special education is so expensive? Good luck with this week's module.